Hello, my name is Cecelia Klingele. I teach criminal law, procedure, policing, and sentencing at the University of Wisconsin Law School. Over the last several months, there has been a lot of conversation about the fact that families trying to enter our country are being separated by our government at the borders. There's a lot of conflicting information out there about how often this is happening, under what circumstances, where children are being detained, what resources are being provided to families, and about how our government should respond to individuals who seek to enter our country for refuge or for other reasons. Today, I want to talk about just one very small piece of that larger and more complicated issue, and that's the question of whether the law requires that families be separated when they are captured entering our country illegally. You've probably heard the sound bites.
Children can be taken care of quickly, beautifully, and immediately. The Democrats forced that law upon our nation. I hate it. I hate to see separation of parents and children. The Democrats can come to us as they actually are, in all fairness, we are talking to them, and they can change the whole border security. We need a wall.
They call it zero tolerance, but a better name for it is zero humanity, and there's zero logic to this policy.
Confused much? I don't blame you.
So, does the law really say that kids and parents have to be separated at the border?
That's a really good question. To answer it, we need to start with some basic facts about criminal law. Prosecutors have a special role in our criminal justice system, deciding when to respond to legal violations with criminal charges and when to respond in other ways. As the Supreme Court has explained, in our system, so long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision whether or not to prosecute and what charge to file or bring before a grand jury generally rests entirely in his discretion.
Wait a minute. If someone breaks the law, doesn't a prosecutor have to charge a crime?
Nope. In fact, we count on prosecutors to use criminal law, the ultimate state power, only when it's necessary.
Our justice system relies on police officers and prosecutors to decide when and how the government should respond when people break the law. Most of the time, the government uses only a tiny amount of its vast legal authority. When deciding how to respond to law violations, prosecutors typically look at factors such as the seriousness of the behavior, any danger to other people that may occur, and circumstances that make the behavior more understandable, such as life challenges faced by the offender. The power to decide whether and what to charge is called legal discretion. It is probably the most important power that prosecutors wield. It is also a power I spend a lot of time teaching law students about, because it's complicated, ambiguous, morally fraught, and absolutely essential to justice. The truth is, there's a lot of crime in the world, some serious, some less serious. Importantly, there is a lot more crime than law enforcement could ever possibly prosecute, charge, sentence. And to be honest, we wouldn't want them to. That's one of the reasons we elect prosecutors, who are called ministers of justice in the ethics code that governs lawyers. Prosecutors take on the complicated role of making morally relevant decisions about when and how to invoke the power of the state against people. Sometimes they charge crimes. Sometimes they offer services. Sometimes they impose fines. It's a big responsibility that requires careful judgment.
But I still don't understand how a person can be caught committing a crime and not be treated like a criminal.
Let me give you an example. Imagine a guy decides to drive really fast on the highway one night, say 85 in a 65-mile-per-hour zone. Now imagine it's raining lightly, so visibility is reduced. If that guy gets pulled over by a police officer, a number of things could happen. The officer could arrest him, jail him, and ask the prosecutor to charge him with the crime of recklessly endangering safety. More likely, the officer will write him a ticket requiring that he pay a hefty fine for speeding. It's even possible, though far less likely, that the officer could send the guy on his way with a stern warning. Even though the law authorizes the police officer to arrest the driver and refer him to the prosecutor for a serious criminal charge, there is no law that requires the police officer to make the arrest or requires a prosecutor to later charge the crime. Most of the time, officers handle traffic violations that could be criminal or civil by using the less punitive approach and fining the person. In a similar way, when families are caught entering the country at an unauthorized location, border agents and federal prosecutors have many options, some criminal and some civil. One option, the option that the government has chosen to pursue since April 2018, is to charge all adults entering the country illegally with the crime of illegal entry under Section 1325A of Chapter 8 of the United States Code. Contrary to past practice, the government is charging this crime even when offenders have not previously tried to enter the country, and when the people entering are seeking asylum because they face danger in their home countries. The law at issue states that any non-citizen or non-resident who, for the first time, tries to enter the country in a way not designated by immigration authorities shall be fined or imprisoned not more than 6 months, or both. We call this misdemeanor crime illegal entry. If a person is charged with the crime of illegal entry, he or she may be placed in jail until the criminal case can be resolved. Because children cannot legally be held in jail for their parents' crimes, when parents are held in jail as a result of being charged under this statute, the children must be placed in a different location. But just as the police officer in our earlier example did not have to arrest the speeder for reckless driving, the federal government does not have to charge parents entering the country illegally with a crime. And even when they do, they don't have to jail the parents and take away their children. They can release the family together in the community or temporarily place them together in immigration detention while the court resolves the misdemeanor charges. The decision to separate families is a choice, a discretionary decision to use the criminal law to divide parents and children instead of responding in a way that would not separate families.
Family immigration presents lots of challenges too complex to discuss in one short video, and border practice is changing rapidly. But despite the many complicated questions confronted by immigration officials, this much is clear. For many decades now, through Democratic and Republican administrations alike, the practice of our government has generally been to avoid charging first-time offenders with the crime of illegal entry. Instead, families have often been paroled or bonded out to the community while they wait for the resolution of their legal cases, many of which involve claims of asylum that are recognized and protected by both U.S. law and international human rights treaties. In the more recent past, families have sometimes been detained together in immigration detention centers as they wait to be granted asylum or to be deported back to their home countries. In other words, there are legal alternatives to family separation. Section 1325A gives the government the power to do what it is doing, to charge every mother and father who enters this country illegally with a crime, and on that basis to justify taking children away from their parents. But the law does not require the government to do so. In an exercise of discretion, that is a choice our government is making freely.